Regulating health and safety. In this section, the legal reason for managing workplace health and safety relate to the framework of laws that govern the conduct of business and organizations. The International Labour Organization (ILO) has set out Conventions C-155 and Recommendation R-164, which apply to workplace health and safety standards. Most countries and regions have established legal standards that meet or exceed the minimum standards set out in C-155 and R-164. This legal standard places a duty on the employer to ensure that workplace, work activities, and work equipment and substances are, so far as it is reasonably practicable, safe and without risk to health. The legal standards also place a duty on workers to look after their own and other people's health and safety. Failure to comply with these legal standards may lead to enforcement action by authorities or prosecution through the country's criminal courts. Successful prosecutions usually result in a fine, but may result in imprisonment. Work-related injuries may result in compensations being paid to the victim. In some countries, this is achieved by legal actions through the civil courts, while other countries may have worker compensation schemes for this purpose. Legal reason for managing workplace health and safety. The legal reason for managing health and safety relates to the framework of international and national laws that govern the conduct of business and organizations. Most countries have laws that set standards for how organizations should conduct themselves with regard to management of health and safety risks. Failure to achieve these legal minimum standards can lead to enforcement actions by authorities or prosecution before the courts. Successful prosecutions can lead to a fine, and in many countries, to imprisonment for the individual concerned. The international framework. There are no truly global laws governing workplace health and safety. Most countries have their own laws, developed over the years to tackle their own issues and concerns. However, countries often end up adopting similar basic approach to protect the health and safety of their people. The detail may vary from the underlying principle are the same. A key player in the area of international legal standard in health and safety is International Labour Organization (ILO), which is an agency of the United Nations (UN). Most countries are members of the ILO. The two primary outputs of the ILO are conventions and recommendations. This sets international legal standard. Conventions and recommendations confirm the basic of details. Health and safety is a priority around the world. Legislation in each member country, the result being that the basic minimum health and safety standards are adopted. The detailed provisions will still vary as its member states implement the standards in a nationally approved way. In 1981, the ILO adopted the Occupation Safety and Health Conventions (C-155). These describe a basic policy for health and safety at both of nations level and the level of the individual organizations. Regulating health and safety. The Occupation Safety and Health Recommendations 1981 R-164 supplement C-55 and provide more detailed guidance on how to comply with the policies of C-55. In particular, it identifies obligations that might be placed on the employer and employees in order to achieve the basic goal of safe and healthy place of work. Many countries that belong to the ILO have ratified C-155 and R-164 and had them legislated to put their requirement into nations or regions law. In C155 and R164, there is a general recognition that most of the responsibility for ensuring good standards of health and safety at work lies in the employers, since they provide the work, the workplace, the tools, system, and methods used, etc. They also recognize that individual workers have responsibilities. Though the legal wording varies between countries, the general theme is that employers and workers must exercise reasonable care to ensure safety and absence of risk to health. Employees' responsibility. Article 16 of 1655 identifies some basic obligations placed on employers. First, to ensure that the workplace, machinery, equipment, and processes under their control are safe and without risk of health. So the second is to ensure that the mechanical, physical, and biological substance and agents under their control are without risk to health. So the third, to provide adequate protective clothing and protective equipment to prevent risk of accident of the adverse effect on health. Source C155 Occupation Safety and Health Conventions 1981, abbreviated copyright International Labour Organization 1981. These duties are very generally worded in the conventions. R164 expand on what they might mean in practice. It identifies some practical obligations to meet the objective of the Article 16 of C55. Topic focus. Which one? Specifically, Article 10 or R164 put the following obligation employers: provide workplace and work equipment, use the work methods and which are safe posed to risk to health, provide appropriate instructions and training, provide necessary supervisions, put in place health and safety arrangement adapted to suit the size and nature of the undertaking, provide any necessary personal protective clothing and equipment free of charge, ensure that the hours of work do not adversely affect employee safety and health, take measures to eliminate any extreme physical and mental failure, set up to date with the knowledge in order to comply with their law. In this way, the responsibility is placed directly on the employer. However, it is also recognized that individual workers have a critical part to play in keeping workplace safe. So workers are also given duties. Regulating health and safety 1.2 Worker responsibility and right. Article 19 of C155 states that all workers and their representatives have to cooperate with their employees so that they can fulfill their safety obligations. Teh, sing raras teh, tidur na teh. Hey, sing raras tidur na. The convention and recommendation do not only put a duty of workers, but also give those workers rights. In addition to the basic right to the safe workplace, Article 19 of C155 gives workers the following rights: the right to be provided with adequate information and actions the employers has taken to ensure occupation safety and health, the right to the necessary training in occupation safety and health, the right to consult by the employers on all matters of occupation safety and health relating to their work, the right to leave a workplace which the worker has reason to think present on imminent and serious danger to their life or health, and not be compelled to return until it's safe. More further information on the ILO conventions and recommendations can be found at www.ilo.org. Global Standards Introduction to International Labour Standard. The role of enforcement agencies. There is no harmonized global standard for enforcement of health and safety law, so legal and enforcement systems vary between countries. There are, however, some general principles which normally apply. Each country or region has one or more enforcement agency or authority responsible for ensuring health and safety law, such as an agency is effectively the health and safety police force. In some circumstances, the agency may actually be or may enlist the health or national or regional police. This agency often provide advice, investigate workplace accident, take formal enforcement action to force employers to comply with the law, and start criminal proceeding against person or organization they believe have committed offense. Regulating health and safety. Many countries have a separate fire authority with a role in enforcing fire safety legislation and advising employers. In some countries, insurance companies fulfill a major role in enforcing safety by carrying out inspections and audits on a regular basis. This can help to improve standards, as the insurance company can demand increased insurance premium or refuse to provide insurance cover at all unless standards are improved. Consequence of the compliance. A breach of health and safety legislation is usually a criminal offense. Wherever you are in the world, failure to meet legal standard might lead to formal enforcement actions. An enforcement agency might force an employer either to make the improvement with the workplace with a given time period, or to stop carrying out high-risk activities altogether until improvements are made. Failure to comply with formal enforcement action is usually considered to be an offense itself. Prosecution of the organization in the criminal court. Successful prosecution might result in punishment in the form of a fine. Breaching health and safety law can lead to criminal prosecution. Prosecution of individuals such as directors, managers, and workers. Successful prosecution might result in punishment in the form of a fine and imprisonment. As well as the criminal law consequence, there is also the matter of compensation for workers and other injured by the workplace. But the workplace accident, depending on the region or country concerned. These might involve the worker taking legal actions against their employers through the civil legal system and having to prove that their employers has been negligent and was therefore to blame for their injury. Claiming compensation from national or regional compensation scheme with no requirement to prove negligence or blame through the use of the legal system. Definition. Civil law. The branch of law concerned with the right of individual, for example, compensating people from harm that is done to them through no fault of their own. Other international standard. The International Organization for Standards, ISO, is the world's largest developer of management standard. ISO has developed ISO 9001, the quality of management standard, and ISO 14001, the environmental management standard. Whilst they are not legal standard, they have been adopted by many companies throughout the world since they demonstrate good management practice. The result is common approach to managing quality and environmental matters. There is an international recognized standard for health and safety management. The ISO standard ISO 45001 Occupation Health and Safety Management System is compatible with other management system standards such as ISO 9001 and ISO 14001. Regulating health and safety. At the technical level, ISO has been responsible for developing health and safety standards to which machinery, etc. should conform. Example, ISO 12100 safety or machinery. As a compliance with this recognized national legislation often refer to them. Sources of information. Information on national standard can be obtained from the relevant national regulatory bodies, and who publish guidance documents which provide information on the legal standard required. Many of the regulatory bodies have websites which are valuable source of information, such as Health and Safety Executive, HSA, HSE in the UK at www.hse.gov.uk. Occupation Safety and Health Administrations, OSHA, in the US at the www.osha.gov.gov. European Agency for Safety and Health at Work, EU, osha.europe.eu. WorkSafe in Western Australia at www.commerce.wa.gov.au. Study question. Number 4. Identify 3 of the legal duties that employers has to comply with. So the 5th is identify 2 or legal duties that worker has to comply with. And number 6 is what are the consequences for the employers of non-compliance with health and responsibilities? Suggested answers are at the end. Safety, legal. Who does what the organization? Who does what in the organization? In these sections, ultimate responsibility for ensuring that the workplace is safe and free of health and risk rests with the employers. Directors and senior managers have a duty to ensure that their organization meets their obligations. In particular, they are responsible for setting policy and all locating resources to allow that policy to work effectively. This includes the provision of competent health and safety advisors. They must demonstrate clear commitment and clear leadership, which usually includes appointing a senior manager with responsibility for health and safety. Middle managers and supervisors have the duty to ensure that the part of the organization under their control is safe and free of health risks. They execute the policy of their organization operationally. When 2 or more employers share workplace, they must cooperate and coordinate their activities to ensure good health and safety standards. When a client takes on the service of a contractor, both parties have shared responsibilities for ensuring good standard of health and safety. The client must carefully select contractors on the basis of their health and safety competence. This can be done by looking at the contractor's policy documents, accident and enforcement history, reference, qualifications, and experience. The client must ensure that the contractors carry out which risk assessment and develop without statement for their work so that the work is properly planned and coordinated. The client must monitor and manage contractors to ensure that they work safely to agreed methods. The employer. Responsibility for ensuring that the workplace is safe and free of health and risk risks. Which employer? As we noted earlier, the ILO Convention C155 and recommendations R164 make the duty of the employers clear. Those international standards are normally reflected in local law. Look again at the approved section in this element to remind yourself of the employer's duties. It is important to consider who an employer's own the duty to their own workers or employees to ensure their health and safety. Other workers who might be working within their workplace but are not direct employees, such as casual workers, agency workers, and contractors. Workers who are not their employees and are not working in their workplace but are carrying out work in their behalf, such as contractors installing into the piece of machinery or behalf of the employers or someone else premises. Who does what the organizations? 1.3. People who might be in their workplace but not carrying out work in their behalf, such as visitor. People who might be outside their workplace but are affected by their work activities, such as member of a public passing by. So an employer has responsibility for the health and safety of everyone who might be affected by that they do for work, whether they are their employees or not. Directors and senior managers. Directors and senior managers give an organization its directions and set its priorities. They decide what the organization does, how it does it. In effect, they control the corporate body. They are therefore responsible for ensuring that all of the legal requirements that reach with the employers are met. The top tier management, managing director, manager, supervisor, middle management. However, directors and senior managers are involved in the day-to-day management of the operations side of the organizations. Their role doesn't normally involve doing, but rather setting strategy and allocating the resources. So the responsibility of the directors and senior managers is to ensure that the right health and safety policy is in place. Adequate resources are allocated to establish, implement, and maintain the health and safety management system. This included sufficient funding to deliver the objective in the policy, but also competent personnel to assist in delivery of the policy objective. The right organization structure with clear roles and responsibilities are put in place. A director or senior manager is appointed with specific responsibility for health and safety so that it can be championed at board level. One of the more competent persons are appointed to assist the organization in meeting its health and safety obligations. Contractors are engaged and managed correctly, demonstrating the organization's health and safety responsibility to third parties. The health and safety performance of the organization is reviewed on a regular basis to ensure that the objectives are being achieved and that the objective and measure in place remain valid. Who does what in organizations? Directors and senior managers can have enormous influence over their organization and its priorities. This influence doesn't simply come from their strategic decision making, but also from the way they are perceived by the lower in the management hierarchy. They must demonstrate clear commitment and leadership with regard to health and safety. Middle managers and supervisors. Middle managers and supervisors are involved in the day-to-day operations running of the organization, so are responsible for the health and safety standards within the operations and under their control. Their operations areas of responsibility are normally defined in their job description, and the organization health and safety policy documentation outlined later in element 2. Line managers will operationally responsible for the health and safety of the staff that work directly from their direct report. Staff lower down in the organization charts below their direct report, the areas and activities under their control. The shared responsibilities of joint occupiers of premises. When two employers share a workplace, it is not difficult to imagine that the risk that one employer created in that workplace may affect the employees of the other employer. For example, where two employers occupy offices in the same building, the fire risk created by one employer's effect and safety of the employees of the other. It follows that both employers must cooperate and coordinate their activities to ensure good health and safety standard. This is set out in ILO 6 ILO C155 Article 17. Whenever or two or more undertaking engage in activities simultaneously at one workplace, they shall collaborate in applying the requirement of this convention. And ILO R 164 Recommendations 11. Whenever two or more undertaking engage in activities simultaneously at one workplace, they should collaborate in applying the provisions regarding occupation safety and health and the working environment without prejudice to the responsibility of each undertaking for the health and safety of its employees. In approved cases, the competent authority or authorities should prescribe general procedure for these collaborations. This requires effective communications between employers, the exchange of relevant information, and the development of the approved policies and procedure. This could be carried out in a variety of ways, depending on the nature of the work and work site. So, for example, in multi-story office building occupied by the 10 different business, each employer should provide information on the risk that their specific business creates for other occupier of the building. This can often be achieved by establishing a building management committee. With regular meeting, consultations can take place through this committee, and policies and procedure can be developed and implemented throughout the building as necessary. In this way, a common approach can be developed for the management of joint issues such as fire procedure, security threat response, emergency spill response, site rule, visitors and contractor control, traffic management, etc. It may also be approved to have a site-wide inspection process, common fire drills, and even share waste disposal procedure. Who does what in organizations? If there are specific risks associated with one workplace, then awareness of the issues and the approved response from other workplace can be raised. For example, an agencies that deal with violence offenders may share a building with unrelated business. Those other business will not be understand the risk and prosecution approved to the building as well as a whole. Employers working more closely together, they may need to share risk assessment. This is to ensure that all organizations are aware of the possible effect of any equipment and the substance being used, so that activities can be coordinated. For example, one organization may be using solvent-based paint while an area occupied by another organization personnel. Contractors management. Contractors are used widely in the workplace, either to deliver a specific project or skill, or to deliver extra labor when needed. For example, a site wanting to extend the premises will usually take on a building contractor to deliver the project rather than employing the manpower directly. In the same way, a company may engage a self-employed employee training contractor to deliver a course. Contractors are engaged by clients in a lot of different circumstances of work. A contractor may be engaged to perform in one of service, such as the refining of an IT shoot, or they may be engaged on more permanent basis to provide in-house catering or cleaning service. Quite clearly, it is not in the interest of health and safety for the client to ignore the risks associated with the contractor's work, or for the contractors to ignore the risks inherent in the client's workplace. Share duties. Contractors are responsible for their own health and safety, and the health and safety of others who might be affected by their work activities. A contractor's company, example a cleaning company, is an employer in their own right. Therefore, they owe a duty to the workers, the individual contract cleaners doing the work in the client's premises. Other people, such as the client's workers, visitor the client's premises who might be affected by their work. And the individual cleaners doing the work in the client's premises are workers of the contract cleaning company. Who does what in organizations? Who does what in organizations? Who does what in organizations? They therefore our duty to themselves. Other people such as fellow workers, the client's workers, and visitor to the client premises who might be affected by what they do. The clients, as an employer, our duty to their own workers, others who might be affected by their works, including the contract cleaners in the premises, any other workers in the premises such as other contractors, visitors to the client premises, the individual workers of the clients, also our duty to themselves, other people such as contract cleaner, fellow workers, visitors who might be affected by what they do. Put simply, the contractor and their workers owe a duty to everyone. And the client and their workers also owe a duty to everyone. The key thing to recognize from the above is that the responsibility for ensuring health and safety is therefore shared between the clients and the contractors. It is both parties' interest to ensure that each does everything that might be considered reasonable in a circumstance to discharge their duties and avoid criminal liability. The way that the client's manager contractors can be broken down into three key areas. First, selections of the contractors. So the second one is planning to coordination of the work. So the third is monitoring and managing the work. Who does what in organizations? Planning and coordinations of the work. Information must be exchanged between the clients and the contractor. The client should tell the contractor about the hazard and risk in the workplace, and the contractor should tell the clients about the hazard and risk created by the work. In this way, the work can be planned so that everyone is kept safe. The contractor should carry out risk assessment on the work environment and develop safe working methods to control the risk identified. These safe working methods must be documented and is often referred to as method statement. The client should be examine the risk assessment and method statement to ensure that there are no obvious problem or error. This should happen before the work commences. It is good practice for the clients to demand the risk assessment and method statement are submitted well before the work commences so that problem and conflict flag up. This review process can be resolved without creating delays to the start of the work. The clients and contractors must coordinate their work carefully so as not to conflict. There may be several contractors working on a site at any one time, and activities of one person or organization must not cause a hazard for another in the area. For example, if one contractor is working at their height, it will be sensible to avoid others working beneath them in that area. Monitoring and managing the work. Organization must be made by clients to ensure the contractors compliance with safe working practices. This arrangement should include having a signing in and out procedure, ensuring that the contractors provides a named work supervisors, carrying out site induction training for all contractors workers, controlling high-risk activities with a permit-to-work system. The client will need to monitor the contractor's work to ensure that they are working to agreed health and safety standards. This can be done by monitoring against the risk assessment and method stage when they were developed during the planning stage. If the client identifies that agreed safe working methods are not being followed, then it is in their best interest in stop to work so that issues can be addressed. We will cover permit to work system in a more detail in elementary. Who does what in an organization? Definition: permit to work. Permit to work is a formal documented safety procedure for forming part of a safe system of work, which ensure that all necessary actions are taken before, during, and after particularly high-risk work. This is the definition of permit to work. Okay. Summary: this element has dealt with some of the basic principles of workplace health and safety. In particular, this element has introduced some of the keywords that will be used in this course, such as health, safety, and welfare. Highlighted the three main reasons why an organization has to manage health and safety: moral, legal, and financial. Identify some of the insured and uninsured costs associated with accidents and ill health. Set out the basic requirement for the international standard that govern health and safety, as the ILO Convention C155 and Recommendation R164. Look in some detail at the duties that these two standards place on employers and on workers. Discuss the consequence for employers and workers of non-compliance with legal standard, together with the possibility issue of worker compensations. Note some source of information on national health and safety standards. Look at the various parties with the workplace and the responsibilities that they have the employer for ensuring that the workplace is safe and free of health risks. Senior management for setting policy, allocating resources, and showing leadership. Middle management for making standards happen operationally. Joint occupier of premises for collaborations and coordinations. Explain that the shared responsibilities that exist when work is carried out by contractors for a client. Outline a basic framework for the selections, monitoring, and control the contractors by clients. Exam skills. Introductions. To pass the NEBOSH certificate, you need to perform well during your open book exam. An open book exam means exactly what the name suggests. You can access your study text and other materials during the exam. However, it will require more than simply copying the text to answer the exam questions. You will need to demonstrate that you understand the subject matters, can be applied the topic appropriately. There's need preparing for here we will consider some practical guidelines that can be used to increase success in your open book exam. The NEBOSH International General Certificate Open Book Exam differs from the traditional questions and answer type format, and when answered consists of realistic workplace scenario, which may describe a developing situation such as an incident of safety interventions, and you may be asked to assume a particular role. For example, as safety managers, you will then be asked to carry out some tests. Each test will consist of one or more questions. Your answer will mostly be relevant to the scenario. Wider reading, research, and reference. During the open book exam, you are all allowed to access many different types of resource, such as RRC study text and revisions guide, professionals journal, digital resources, or the internet such as HAC guidance, bilingual dictionaries, etc. Remember too that this is not a substitute for the thorough study of your course materials and specific preparations. In the firm a provision to ensure that you are familiar with all the topic areas included in the syllabus. NEBOSH will not be looking for anything from your answer that has not been covered in the United syllabus. NEBOSH has designed the open book exam to access the same learning outcome to the same level as the previous method examinations. It will measure depth of misunderstanding and require you to apply your knowledge to the scenario given rather than simply recording memorized information. It is therefore very important that you prepare and revise for assessment. Wider reading and research. As part of your preparation, NEBOSH recommend that you should complete wider reading so you don't have to do this during examinations. Conduct wider research to understand how your study related to the real world. To help you this, you should make use the more boxes included in your course materials. This highlight additional research related to the topic you are been studying. Reading them will assist you in increasing the depth of your understanding and applying it to the real life situations. The link is more. Boxes are current at the time of publication of your materials, but may have changed since, example, due to the items being moved elsewhere, being replaced, or perhaps withdrawn from a publication altogether. Your wider readings may also include research during other resource missions in your course materials or research that you have found yourself, perhaps by entering a topic name in a search engine. Always be careful to use only authoritative source for your research, such as government or official website, and to safeguard the security of your personal information. Making use of your resources, NEBOSH states that you are expected to offer your own analysis and presentations of the information gained from the research, so you need to organize your notes in advance so that you can find things quickly. Use your own words to express what you have learned and apply the knowledge you have gained. You are permitted to make reference to source areas of work of other people or organizations. Where you do so, it is important to acknowledge where that information comes from, because your open book exam response must be your own work and you don't want to be guilty of plagiarism and subjected to invention by NEBOSH. Definition: plagiarism. Plagiarize. Plagiarize, to steal ideas or writing from another person and present them as one's own. Okay. Difference: direct citations. You may want to quote specifically from a publication you have assessed. Here you should put the quote in inverted commas and make it clear when it is from, so that reference is below. Example: UK HSE guidance INDG 1623 state that a risk assessment is not about creating huge amounts of paperwork, but rather about notifying sensible measures to control the risk measure the risk of your workplace. Indirect citations. You may just want to refer to information that you have read without quoting from it clearly. In this case, express it in your own words, but make sure that you identify the source. Okay, example, blah blah blah. I think enough for today. Thank you.